So to move to the custody cases then, we're thinking now of the three I mentioned earlier on. So M and the Uchála from the 1970s, Re-JH from the 1980s, and Baby Anne's case from the early 2000s. So what's your sense of this? How do you think it was decided, and what were the issues? Well, okay, so the married couple won. I should have said, incidentally, that in Baby Anne's case, the university students got married. So in 2004, I think, so first off, they're unmarried. The woman becomes pregnant. The child is put up for adoption. 10 months pass. The child having been placed with the Doyles, the proposed adoptive parents. In the interim, after having a change of heart, the couple get married and now count as a family for the purpose of Article 41. And then I never mentioned that, and then initiate habeas corpus application to seek custody of, in inverted commas, their child. So let me just start with that case. In the High Court, John McManamon rules in favor of the adoptive parents, right? It rules against the habeas corpus application. It's appealed to the Supreme Court, and the Supreme Court reverses the decision. So we'll get back to that. Moving back to the early case from the 70s. Let me read you, I think I have an excerpt from what Chief Justice of the day, O'Higgins, said. Now, this is the 6 years has passed case, right? It has been argued by counsel for the adoption board that the plaintiff's failure to take action earlier than they did, that is the genetic parents, with the consequent effect on the child in relation to his surroundings, renders it unjust and contrary to the child's interests to remove him now from the care of the adopting parents. No one can be unmoved by such a plea or feel anything but compassion for all those involved in this human drama. However, in coming to a just conclusion, one must not allow compassion to confuse or permit sympathy to conceal fundamental rights. So in other words, O'Higgins explicitly places the fundamental rights of the marital couple, the parents, over and above the best interests of the child. And the child is taken out of the surroundings that he has been familiar with for 6 years and returned, if you like, to the genetic parents who are now the married parents in virtue of the fundamental rights accruing to families under Article 41. Now, then Re-JH is that little bit of a more complicated case, because the Guardianship of Infants Act 1964, Section 3 of which refers to the best interests of the child. And in light of that, the High Court judge in this instance, Justice Lynch, rules that the child should remain with the adoptive parents. Now, only 2 years have passed in this instance. Of course, there's an appeal immediately to the Supreme Court, or rather the case is referred to the Supreme Court for clarity on how to appropriately interpret the legislative provision concerning the best interests of the child. And here's what's kind of maybe the concept here that's a little bit tricky. The Supreme Court rules that the legislative provision in the Guardianship of Infants Act is to be interpreted or understood with reference to the constitutional provision, Article 41, and accordingly that there is to be a presumption, a strong presumption, rebuttable but strong, that the best interests of the child will be served in the marital family situation. And on that basis, the Supreme Court remits the case back down to the High Court, to Justice Lynch, and Justice Lynch changes his decision. On foot of that interpretation, the child, in other words, returns to the genetic or marital parents, married parents. right? So I guess in this instance, you might say the best interests of the child aren't ignored or superseded in one sense, but effectively they are in that what we get is this notion that the best interests of the child are to be found or served almost invariably in the company and care of the child's married genetic parents. And we get more or less the same outcome in Baby Anne. John McMenamin in the High Court, because of the evidence presented on behalf of the adoptive parents from psychologists, etc., rules that the child should remain. It's appealed to the Supreme Court, and the Supreme Court, a relatively modern Supreme Court. I mean, Susan Denham is on that court, Adrian Hardiman, I'm pretty sure, yeah, Denham is on the court, Adrian Hardiman, Catherine McGuinness, who is no longer on the court, but she's interesting because she was particularly interested in Article 41 and what she, I think, saw as the problems with Article 41. And she effectively said, if you read her judgment, she said, look, I've got to hold my nose here and reach a decision which I think is right in law, but wrong in morality, you know, or wrong as a matter of justice. This child has to be returned despite the child's best interests, you know. And I suppose the Baby Anne case probably was pivotal to the Children's Rights Amendment in the end. But I think Adrian Hardiman's and some of the other judges' positions were a bit different in that they were inclined to say, look, first of all, the Constitution requires that, you know, marital families be under Article 41, be given this protection and respected, but kind of was inclined to say, well, this is what is appropriate as a matter of morality, political morality, in any case. So let me read for you a little chunk of Hardiman's judgment. Hardiman says, it would not be quite true, it would be quite untrue, he says, to say that the Constitution puts the rights of parents first and those of children second. It fully acknowledges the, quote, natural imprescriptible rights of the child and the human dignity of children, but equally recognizes the inescapable fact that a young child cannot exercise his or her own rights. The Constitution does not prefer parents to children. The preference the Constitution gives is this: it prefers parents to third parties, official or private, priest or social worker, as the enablers and guardians of the child's rights. If the prerogatives of parents, if the rights of parents, in enabling and protecting the rights of the child were to be diluted, the question would immediately arise: to whom and on what conditions are the powers removed from the parents to be transferred, and why? So you see Adrian Hardiman's point there. He's kind of saying, look, we're not preferring parents to children. You know, we're just recognizing that, like, children can't exercise their own rights. And we're saying, well, who is the most appropriate agent to vindicate the rights of the child or to enforce the rights of the child? Is it going to be a priest or a social worker, or the state is what he's really getting at? The big bad state, I think. That's my understanding or impression of Hardiman's kind of what he's suggesting there. The big bad state comes in and takes the child and does right by the child. Or he says, is it the parents that ought to be making that decision to vindicate the child's rights? And Hardiman says that the Constitution gets the right balance. The Constitution says it's the parents. Or he's really saying is there should be a very strong presumption that it's the parents. Rebuttable, but very strong presumption. So, for example, if you take a case like Temple Street and D from 2011, decided in the High Court by Jared Hogan, which concerned Jehovah's Witness parents of a child who were refusing a blood transfusion, where the child was, the medicals people were saying, was going to die within a matter of hours if this transfusion didn't happen. Right? So Jared Hogan, I think, was just recently appointed to the High Court at the time and had to decide the case in his house because of the emergency. Ruled without any hesitation against the parents. The presumption, in other words, was rebutted in that situation because the child was going to die in a matter of hours. But in other words, that's kind of what Hardiman is saying. You know, that's where things would need to be at before the family, quote, family decision-making authority is superseded by the state.